Sunday. It's 514 pages long. I really wish it had come out about a month ago so I would have some clarity. I mean, I got through to the extent that I could, but there are so many questions. You would think in 514 pages they could actually answer every question. Really, what else could you want to know after that? But it's so convoluted and confusing. NAR is taking a look at it. They haven't been willing to make any statement about it yet as to what it means. I've taken a look at it. Our resident expert on seller financing, Ranm with Security Escrow, and his attorneys are taking a look at it. So between all of us, we're trying to figure out what this document means. So I don't have answers for everything today, but I think we'll talk about some of the issues because you're going to hear the buzz out there because it has been released. And you're going to have to stay tuned for the rest of the answers. Look to our website as soon as we have some answers to some of these questions we're waiting on. We'll certainly get that to you. Okay, first of all, this is actually pretty clear. Does it apply to real estate brokers? Are you guys considered loan originators under this definition? And the answer to that question is no, unless you get compensated by a lender, a mortgage broker, or a creditor. If you're taking money from one of those people, then for one of three activities, you would be considered a loan originator. That is not typically what you guys do, so I would not be concerned. Because you do not typically take residential mortgage loan applications or assist consumers in obtaining or applying to obtain residential mortgage or offer to negotiate terms of a residential mortgage loan. Okay? But if you were so inclined to do that, I would suggest you not. Okay? Because that might put you into this category, especially if you get a cup of coffee out of it. Okay? You may fall into the definition, and this is interesting because we wouldn't necessarily think of this, if you refer as a consumer to a mortgage originator or a creditor, because they consider referring as a component of offering. Again, compensation is involved, and there's already a rest of the world to deal with that, isn't there? So I'm not exactly sure why we had to say that again, but nonetheless, I wanted to point that out. It's not a problem. I mean, there are a couple of scenarios that would not be a problem. The broker does a BPO for ABC lender and gets money, but nobody here is doing that because that's a violation of state law. So, assuming that we are successful on our yet third attempt to get that law changed here in New Mexico, and you guys actually can receive money for BPOs, if you did that and then you helped a consumer find or negotiate a purchase, and then that consumer happened to go back to the same lender to get the loan, that's not considered a violation. Also, broker represents ABC lender who's selling a property. So they foreclosed on a property, now it's back in their portfolio. You're going to sell it for them. They're clearly a lender or creditor. You're going to get paid a commission by that lender or creditor. Is that a violation? And we've established that is not a violation. When could it be a problem? It could be a problem if you are negotiating real estate contracts, terms of real estate contracts. If the person making the seller, who's providing the seller financing, is considered a creditor or a loan originator under TILA. So what does it mean? It brings us to the question of what does it mean to be a creditor or a loan originator under TILA? Well, a creditor is someone who extends credit secured by a dwelling more than 5 times in the preceding calendar year. That makes you a creditor. I don't think we have a whole lot of people that fall into that category who are providing seller financing in our state. Or in the event that it's a high-cost loan, one of those in the 12-month period. We've not been all that concerned about the creditor definition because that's been the creditor definition under TILA forever and a day. So that's not the issue. The issue is, when do seller financing become loan originators under TILA? Because that's the whole new section that was developed. It's unclear if seller finance, and I'm going to talk to you about all these provisions, but at this point it's unclear if the seller financing provisions only apply to sellers if they're offering high-cost mortgages. Okay? There's a possibility that's what it says, but I just can't tell. I can't tell, and we just need to get into it further. And because of the conference and everything, I've hardly had enough time to sit and digest it all. When we talk about high-cost mortgage, I mean, in this context, high-cost real estate contract.
So any seller carryback issue?
That qualifies as a high cost. And that's another issue. You know, they use the term high-cost mortgage, and so that's my concern is, you know, maybe they're just using that to cover everything, real estate contracts, deed of trust, you know, all of those things. Again, not clear, but for purposes of perhaps the things I'm about to talk to you only applying in certain circumstances, they would be high-cost real estate contracts. Yes. But again, it's not clear from the rule, and I wish I had clarity today, but I don't. And there's a possibility that's not the case. It's a possibility this applies to all real estate contracts. So we're going to be doing a real estate contract anytime between now and in June. It's just business as usual.
And it would not be retroactive, right?
No retroactive provisions, so you guys just can do what you're doing, okay? And then stay tuned as to how this will affect. So let's say it doesn't apply just to high-cost mortgages, real estate contracts, whatever this ends up being. Then what does that mean? If that's the case, so the seller is not a mortgage originator if they finance 3 or less sales of a dwelling in any 12-month period if certain criteria are met. We've talked about this for a couple of years now because that's exactly what the Dodd-Frank Act says. The criteria, however, this is something new. Criteria depends on how many dwellings are being financed, or how many dwellings the seller has financed in the last 12 months. Have they done 1, have they done 2, or have they done 3? And that's going to dictate the criteria that we're talking about. And we have a 1 in property exclusion, and we have a 3 property exclusion they've created. Okay. As you recall, under Dodd-Frank, there was just the 3 and 12 provision, and there was no other provisions. But they've now broken this out into 1 property in 12 months versus 2 or 3 properties. The 1 property exclusion, no more than 1 property or dwelling is financed in a given 12-month period. In this particular case, when we're talking about 1 property, the seller has to be a natural person, estate, or trust. The buyer must be a natural person, estate, or trust. And that's relevant because some people that purchase properties put them in an LLC, create a little corporation for them. They cannot take advantage of this 1 property exclusion. Okay? They would have to use the criteria for 2 or 3 properties that we're going to talk about in a minute, because this exclusion is only available to natural persons. Natural person does not include an organization. Okay? Estate and trust are included here as well. 1 and 12 provision cannot be used by builders. All of these, 2 and 3 as well. Builders can no longer use these, the seller financing. The financing, the repayment schedule must not result in negative amortization, but it doesn't preclude balloon payments. There's 2 categories now. It used to just be, I mean, at Dodd-Frank we had, if you did more than 3 transactions in a 12-month period, it had to meet certain criteria. Under the regulations, they have a more lax criteria if you're only doing 1 transaction in a 12-month period. But if you're doing more than 1, you're doing 2 or 3, you still have to meet certain criteria, and those criteria are a stricter criteria that we're going to talk about in a minute. So if you're only doing 1, you have a seller who wants to provide seller financing on 1 property. He's got a house. He wants to sell his house. He's a natural person. He doesn't do this as a business. He's not going to be doing any more of these in the next 12 months. He didn't do any more before this. This is 1 house. This is the criteria that we're dealing with. Okay? Now, we're going to talk in a minute about what the provisions are if he wants to do 2 or 3 transactions in that 12-month period. Okay? So again, builders can't use them, but you can use balloon payment. You have to do an adjustable rate must be based on the index. You can do either a fixed or adjustable rate. It adjusts after 5 years. You have to have a reasonable index that you're basing that on. And then we get into the 3 and 12. So you'll see with the 1 and 12 provision, we have only individuals, no corporations using them. We have balloon payments are allowed, though builders can't use them, but balloon payments are allowed. You'll see that you have to do the fixed or adjustable rate, but you'll also see what's missing. Because the ability to repay analysis. No ability to repay analysis. Is that what you're going to say, Rick? Yes. Yes. You come sit up here in the front. No, I want you to. There's no ability to repay analysis. So So as you recall from Dodd-Frank, when we talked about 3 and 12, it was basically saying you're going to have to do that ability to repay analysis on every single transaction, 1, 2, or 3. That's been taken away for the first one. So you don't even have to find out if the buyer can make the installments of the payments. That's not necessary under one. Okay? So it's a laxer standard, okay? And that's great news because they proposed these regulations. They came out with some proposed regulations last September. And the proposed regulations didn't make this distinction between 1, 2, or 3. And they were actually looking at requiring the seller to go through the same ability to repay analysis that the lenders go through. The ones we just talked about the ability to repay and the QM, they were looking at making the sellers go through those hoops, jump through those hoops. So this is great. I consider this a success. You know, the fact that the first time you do this, if you're not in the business, you're a natural person, you can do balloon payments just like we've always done. You don't have to do an ability to repay analysis. The only real issue here, well, you know, builders aren't going to be happy about that, of course, but you know, and you have the fixed rate. I mean, that term is dictated now, whereas before it was not. But you know, I feel like there's some success there, and I want to say also that Ranm and Rick and NAR because of Ranm and Rick, were really wonderful in getting all of this information to the Consumer Financial Protection Bureau and getting them to consider this. I attended the NAR conference. It's probably, how many of you went to the NAR conference in Orlando recently? Yeah, quite a few of you did, yeah. And there's a legal seminar that I attend at all these conferences. And when I get up, everybody just kind of shakes their head because I've been talking about this for 2 or 3 years, you know, since the law came out. And I asked all the attorneys that were sitting in the room that were supposed to be representing all the associations from around the nation, how many of them filed comments about this issue with the Consumer Financial Protection Bureau when they released those proposed regulations, and nobody's hand went up. Not one. So, I mean, it's just amazing to me that nobody else is being affected by this. I just think that I think mainly they just haven't really been aware of it as much as I've been trying to get the word out there. But nonetheless, I mean, the noise that we have made has been heard, and this is a great success for us. So even in the event that we determine that all these rules and restrictions don't just apply to the high-cost mortgages or high-cost real estate contracts, we still, for the first one, you're not going to see a big impact.